the screen. Um, yeah, we all have some probably notion of what civility means, but I thought there's a few definitions that seem on point here. Obviously, politeness and courtesy in behavior or speech, to control one's passions, a deeper understanding of others, speaking in tones of voice that are appropriate to the circumstances, respectful of others' rights to express their views, even if you disagree. And obviously, in our profession, that it's contentious by nature, we've probably all come across some of these issues or had people that probably violated them. In doing a little bit of research, I noticed that a lot of organizations have pledges and essays about civility. So it seems to be a problem across the board, not just amongst attorneys. I noticed, like in Canada, the Ontario Medical Association had a pledge to respect others and yourself, to be aware, to communicate effectively, to take good care of yourself, and to be responsible. Now, the history here, just to give you a little background as to why California now has a continuing education requirement. Apparently, we're the last state bar that has done that. Apparently, that was already going forward with all the other states. And earlier, uh, that was proposed and tried, and there was so much a discussion about how vague maybe the definitions were or how it was going to be enforced. And there was just a lot of pushback, so it didn't happen until recently. But in 2019, a group of 40 judges and lawyers decided that something had to be done. So clearly there were issues, and judges were seeing that in the courtroom as well as us in our practice. And so a California Civility Task Force was created and presided by Justice Brian Curry of the Second District. And in 2021, so it took them a couple of years of talking about it and getting feedback from the bar members, et cetera. And they proposed various things. And just end of last year, 3 of them were taken into our new requirements. And one of those was to reaffirm a yearly oath about civility. That's 9.7. The second was to modify and adopt a new rule called 8.4.2, which was to make incivility a disciplinary offense. And 3 was to require the 1 hour of continuing education on civility. Now, a short version of the 8.4.2 indicates, in representing a client, a lawyer shall not engage in incivility in the practice of law. Incivility means significantly unprofessional conduct that is abusive or harassing and shall be determined on the basis of all the facts and circumstances surrounding the conduct. Okay, with that, um, there are several resources that you can look at civility standards. The state bar has a attorney civility and professional toolbox. When I went to that toolbox, it basically listed all of the different bar associations that have pledges. Marie and I belong to ABOTA, Los Angeles County, and they've had a civility pledge forever. If you're a member of ABOTA, you're supposed to take the civility pledge. You can be kicked out of ABOTA by a fellow member for violating that pledge. Although I don't remember anybody actually have that happen to them. And then all the various bar associations have civility pledges. For example, the Los Angeles Bar Association has their civility pledge. When you become a member, you're supposed to pledge, take that civility pledge as a part of a member of that bar association. So for background, you can go to the state bar resource. But like I said, when I went to the civility state bar site, the toolbox wasn't helpful at all. I didn't find any good information on that whatsoever. So um, that was not helpful whatsoever. Um, there is also guidelines for civility and litigation. Every county superior court seems to have a guideline, and Los Angeles County has its own guidelines. It's Chapter 3, Civil Division, and it's called Guidelines for Civility and Litigation, and talks about your conduct in written communications, communications with adversaries, depositions, document demands, interrogatory trials, etc. So, in dealing with the court. So, that's another resource for looking at civility guidelines. Marie and I found about the best of all of our research. We both did independent research on the subject. And the best thing we found, and I'll try to share my screen with Maria, was the, and we'll give you credit, by Judge Michael Marcus at ADR Services. And it was excellent. Really went through all law, the case law, and case examples. Yes. So we're going to go through that a little bit on our own tonight and go through that and give real life examples that Maria and I experienced of uncivil behavior. And we have war stories. And then if anybody has a war story that they would like to share, I think they're always fun, amusing. And Bob, I bet you got 1,000 of them of uncivil behavior over 50-year plus practice, right?
Oh, yes. And I've been uncivil on many occasions. In fact, I sent out a email to county council with capitalizations, exclamation marks to tell them to turn the damn water on for my client who has been out of water for well, she's been out of water for about a year, but we finally got it turned back on, and then they turned it off again, and she's been without water for a week, and I can't get their attention. Sometimes you have to be uncivil.
Judge Marcus's essay is only 13 pages, so I recommend downloading it, printing it, and reading it, at your leisure and thoroughly. It is really helpful, as Lori indicated. Yeah, but we're going to go through some of the key parts of it. We're not going to read from it, but we're going to apply real life experiences. He first says attorneys are obligated to treat each other with respect. And he talks about to respect the legitimate interests of fellow members of the bar, the judiciary, and the administration of justice. And he gives some examples of prosecutors misbehaving. He seems to mostly cite cases involving prosecutors where the prosecutor kicked people, other counsel, or they demeaned the other side. And they said that, they hold higher standard being prosecutors because they represent the people in whose name they serve. So he felt that prosecutors had a higher standard, and he cited some cases. And we all know this behavior, this uncivil behavior. I think because one of the things Maria and I talked about at length is because now everybody's on Zoom, right? We talked about this Zoom depositions, Zoom court appearances. I think when you're face to face with another attorney, I think it's more difficult to be uncivil to that person or to be abusive to that person if you're face to face with them. What do you guys think? Do you have some real life examples, some recent Zoom depositions that you can talk about? Anything?
Well, I think the only reason why a Zoom deposition will be better than a regular deposition for being civil is if it's recorded. A long time ago, I started to always have the depositions recorded because of the fact that so often you would get opposing counsel hollering or doing this or that or the other thing, which wouldn't show up on the transcript. And you find if you've got a recording there, that tends to tamp things down.
Yeah, that's a good point. I notice when reading deposition transcripts, you don't get the tone of voice. So if the words are appropriate and not abusive, then you don't get that sense that the person was, badgering your client or being impolite to you, etc. So you have a good point there, Robert. But I don't know. The last bit of depositions I did like 8 in a row. They were all Zoom. Counsel was abusive in terms of objecting to every single question, uh, and some of the objections weren't even relevant to the answers or the questions or the answers. So in terms of that, I think that was abusive. I think that objections that are not applicable, I would slack if they were a new lawyer, they've just been practicing a couple of years because they're learning. But somebody that's been in practice as this attorney for more than 15 years, making an objection, a lot of them that weren't even applicable, is I think abusive and uncivil conduct.
You're fading in and out, at least as far as my hearing is concerned.
Okay. Jason, am I going in and out? Can you hear me okay? Oh, okay. He's muted.
Sorry about that. I was on mute. Yeah, if you
Yes.
maybe scoot back just a tad, that might be the issue. I don't know if you're not hitting the mic correctly, but it is.
Okay.
You're in there. It is.
All right. So we'll hang back a little bit, but I think excessive objections at a deposition or even a trial. Now, at a trial, you got a judge. Hopefully, he'll stop it. He'll unless you got a really weak judge. But if you have somebody that's fair and really is impartial, they'll stop it if it looks like it's abusive. In front of a jury, it can help you because a jury can hold it against that attorney that they look like they're hiding evidence. But in terms of deposition, I think it's uncivil behavior. But again, what can you do about it? You just go on, get the answers to the questions as best you can. Yeah, I see it a lot where you get the vague and lacks foundation or calls for speculation when the question was like, was there a car behind you? Which would be a yes, a no, I don't recall, I don't remember. It seems like people are taking the old adage from, what is it, a Watergate attorney who said, I don't want to be a potted plant. It's like they feel they have to put something on the record, even though you're taking a perfectly acceptable, reasonable deposition. Okay, so the next head note is litigation should not be conducted for the purpose of harassment. And it talks about Sorensen versus the state bar. In the behavior, the person's associate, an employee, ordered a copy of the deposition transcript, was mailed COD. The associate refused to accept the transcript. The reporting service mailed another copy and enclosed a bill for $94.05. They disputed the bill and told the client to only pay $49. The client paid the $49, but didn't reference any invoice, so they didn't credit it to anything. Ultimately, the associate responded falsely that the bill had been forwarded to the client for payment for the $94. Then the associate concluded the bill was unreasonably high and that the deposition service had already been paid $49 by their client. And the reporting agency had no record of it, so they went to small claims court. When they were in small claims court, they didn't show up for it. And then then after that, they filed a municipal court complaint for fraud and deceit against the owners of.
Get it out.
Did you hear that, Bob? Can you hear that?
I can hear you now, but you were having problems with.
Okay.
It's not just Bob. So it's, yeah, there's some fading in and out here too.
Okay.
Thank you, Catherine, for indicating that I'm not just an old crank.
So anyhow, over this bill, this court reporter bill, they filed a lawsuit. Subsequently, the attorney for the court reporting agency got the case dismissed, and they had to, in the end, I'll shortcut it, had to pay over $4,000 in legal fees and expenses. So that was a case where they determined that the attorney and the young associate had been, it was uncivil.
Was it a state bar case or what?
It was a state bar case. So somebody must have filed a complaint with the state bar. Attorneys should not engage in frivolous and oppressive discovery. They cite another case, Tenderloin Housing Clinic versus Sparks. This case talked about an attorney.
Are you holding your paper up in front of the microphone?
No, it's not anywhere near the microphone, Bob. Can you hear?
Well, I couldn't there a while back.
Okay. In this case, Tenderloin Housing Clinic versus Sparks, basically what happened is the defense attorney, the plaintiff attorney notified the defense attorney that they were on a prepaid vacation to England. And when they were gone, and asked that the hearing not be set on that date. The attorney set the hearing date. The attorney who was on vacation from England on the prepaid vacation had to do the hearing over a court call. We couldn't have witnesses there. Then the attorney, knowing that the defense attorney, knowing that the attorney was still in England, set depositions, refused to continue those depositions. Then the attorney comes back early on a one-way ticket, incurring a lot of cost, losing money on the prepaid vacation, gets back only to find out the day before the depositions were canceled. So the court determined that this was all behavior that was uncivil and that was all sanctionable. And they cite Los Angeles Superior Court Local Rule 7.12, setting standards for taking depositions, trying to get agreement on mutual dates. I would always, in my practice, I would go ahead and notice depositions. But when I got a call from counsel saying that was a bad date or a letter objecting to that date, I would call the attorney or their secretary and get an agreeable date. And I think that's a very civil thing to do, to be mindful of people's vacation times. I think that's civil behavior, especially when they're prepaid vacations, to set depositions that are on mutually agreeable dates for the parties and witnesses. Now, sometimes if you serve a witness, you have a date, you serve the witness, it's difficult to undo that date if it's a served witness. So that's kind of an exception to maybe not taking that, especially if it's a critical witness, that witness's deposition off calendar in another date. Hey, you want to take the next one? Yeah, let me, I was going to give you some examples as well that Judge Marcus, being a judicial officer, has seen in his courtroom. like an attorney, a public defender in a case said, this court obviously doesn't want to apply the law. That was considered obviously uncivil behavior. And the judge wanted an offer of proof before a particular witness could be called. And that was the comment that was made. Or in the case of Hansen versus the Superior Court, an attorney stated that a client had not received a fair trial. That holding asserted, that was uncivil behavior. Loudly sedating ha or ha ha, or making noises accompanying the judge's ruling or comment in the courtroom. Clearly, that's uncivil and inappropriate behavior. One example, a judge had advised an attorney to move on to a new point in his cross-examination of a witness, and the attorney replied, I will not move on. I will not move on until you haul me away. This is the most important issue of the case, and you're not going to convict my client. And the judge indicated, I talked to you at length before we started about this, and the attorney replied, you're not my mother. Clearly not something you want to be saying in front of a judge. Right? Another instance, a prosecutor, despite being ordered by the court not to comment on the defendant's absence, did so in a final argument, stating, because I can and I'm within the rules of doing it. Another example, of deputy public defender used the term prosecutorial misconduct in front of the jury after having been ordered not to do so. Then, after the court advised the jury to disregard the statement and that there was no evidence of any misconduct, the public defender remarked, ladies and gentlemen, we are here. We should all play by the rules. Another example of obviously is appearing in court under the influence of alcohol or other intoxicating substances. And I had a personal experience some years ago where a trial was concluded and the jury was deliberating over the lunch break, and we were to return. And the other attorney, who had an intoxication problem, simply did not show up to take the verdict. And I actually felt empathy for his clients who were sitting at counsel table by themselves, having to receive a verdict.
Have you ever had the situation where the judge was under the influence?
Well, that would have been Robert O. Young.
I haven't, but
He was.
And
I did many trials in front of him, and after going to the Great Wall at lunchtime with his buddies, he would come back pretty much, two sheets to the wind, as they would say.
and quite a number of others.
yeah.
And of course, I would have to admit, I have stood up in front of a judge and said, I will not instruct my client to do so, and have been held in contempt and not convicted.
You're a firebrand, Rob.
No, well, the thing is, the judge
Clearly, you're right.
was absolutely wrong. He was ordering a deed to be executed, which would have violated an IRS lien, and in a couple of other instances where the judge was absolutely wrong. And I think it is appropriate, if the judge is absolutely wrong, you have an obligation to protect your client, even though it is undoubtedly uncivil.
Well, I'm sure there's instances where, uncivility in that case is one. Attorneys shall honor agreements between themselves. There's a case of Bryant versus State Bar, another state bar. Can you hear me, Bob?
Now I can hear you.
Now
but
we can.
Before.
Okay. It may be that I'm not talking into the computer enough. Let me talk into the computer.
Maybe you need a different microphone.
It's definitely when you turn away, it cuts out.
Okay. All right. So I think that's the issue, maybe, is that I'm not close.
And you're a little too close again.
Okay.
Right there.
Right there? Okay. Bryant versus State Bar, basically.
We can't hear you.
Okay.
Can you hear me now?
Yes.
Okay, in Bryant versus State Bar, the court talks, the state bar talks about.
No, we can't hear you.
Boy, let me
You
see
need
if I,
to- You need to focus your mouth towards the screen, and I think you'll be good. So I don't know if you could hold the paper in front of you or.
okay, let me try that. Okay, in Bryant versus the State Bar. Is that good?
Yes.
We can hear you now.
Okay. Basically, in this case, Bryant was disciplined for violating an agreement not to commence any action on a note and chattel mortgage until opposing counsel had returned from out of town. He made an agreement to do that, and he didn't do that. He violated that agreement, and he went ahead and violated the agreement, did it anyhow. So the state bar found that that was uncivil behavior sanctionable by the state bar. Likewise, Grove versus State Bar, the secretary, I'm sorry. On this one, the counsel on a family law matter calendar motion, and the other side, the wife's attorney, asked for a week's continuance because they couldn't get on a plane out of Los Angeles in time for the hearing. The secretary gave this information to the attorney, and he did not advise the court. And as a result, the judge treated the cause as a default matter. Grove's failure to advise the court opposing counsel's request violated both Business and Professions Code sections 6068 subdivision E. Attorneys must never seek to mislead the judge or any judicial officer by false statement of fact or law, and 6107 moral turpitude. The concealment of a request for a continuance misleads the judge as effectively as a false statement that there was no request. Next, attorneys must respect the court. They talk. Am I losing everybody again?
Yes.
Okay. Attorneys must respect the court. This section talks about behavior in court in front of the court and the difference between being a zealous advocate and being disrespectful to court. And when aggressive advocacy gives way to insolence and disrespect towards the court, and particularly when it denigrates into impertinence, scandalous, insulting, or contemptuous language, reflecting on the integrity of the court, it is a trial judge's duty to protect the integrity of the court. So basically what this section talks about is that aggressive advocacy is permitted, disrespectful comments are not. I was in court about 6 months ago. Defense counsel said to me, I'm plaintiff counsel. Defense counsel said to the judge, "You're not going to listen to me anyhow. I don't know why I bother. You're biased against me and my clients," and went off on the judge. The judge, instead of doing something about it, admonishing the attorney, simply ended the hearing and left the bench. And I think really that kind of behavior, when you're accusing the court of misconduct, is uncivil behavior. It's like Maria saying, rolling your eyes or going, ha, or laughing is disrespectful to the court, because we all, from time to time, disagree with the court.
Right. I'll give you some more examples of making misrepresentations to the court, which, besides having an incivility issue now that the bar has inculcated that in that rule. You also have an ethical violation potentially, and the old business and profession code standards that we've always had in California. For instance, signing a declaration on behalf of a declarant instead of the declarant signing it, making false statements in an effort to disqualify a judge, filing a false statement regarding a client's financial condition. This, of course, would have been in a note collection matter, the other kinds of cases. But in that instance, an attorney filed a declaration in support of a request to set aside an order vacating his client's default, in which he falsely stated that the judgment was the client's major asset, that the client was relying on it to support herself and her daughter, and that the client was living on borrowed funds. Falsely representing unawareness of the date and time of a court proceeding of which the attorney had notice and an obligation to appear. An attorney told a court clerk he was unaware his firm's case was scheduled for oral argument on the calendar date. His associate had previously advised him of the date and time, and the attorney had received a copy of the court's oral argument calendar. Misrepresenting grounds for a continuance. We probably touched on that a little bit. I'm sure people have feigned a vacation or some other personal obligation, and come to find out that that was just ruse because they weren't prepared for an upcoming hearing or trial or whatever the case might have been. The attorney misrepresented that he had to be in a civil matter in Illinois and then in Washington when he didn't, clearly. Concealing and opposing counsel's continuance request, which led to the entry of opposing parties' judgment. I think we touched on that. If the secretary or the attorney had called the office, letting you know something had come up, they requested a brief continuance, and then you don't tell the court, you can lie by omission too, even if not directly stating some falsehood. The fact that you wouldn't share that information or give your opponent, the benefit of the doubt is uncivil behavior and potentially unethical as well. Not advising the court where a client could be reached. I'm sure we've all had some of those situations, or when trying to compel a recalcitrant opponent to take a deposition. Representing to a mandatory settlement judge that a client who had been subject to conservatorship did not believe he was responsible for the accident or the resulting injuries, and wanted the matter to be tried when the attorney knew that the client was dead. Now, that's pretty egregious. And if you do any work vis-a-vis insurance or insurance defense, there are always those times when you find out that the insured is deceased, or a plaintiff suddenly isn't around, and there are appropriate motions to be made, and informing the court of these things clearly.
I'll give a real life example of a war story. I had a trial down in Norwalk. I showed up for the jury trial down in Norwalk. My client was with me. We showed up at 8:30 in the morning. Plaintiff's counsel had a young associate, fairly new lawyer, show up and say that he was in trial and that the matter had to be continued. It would have been courteous and civil, if that were true, if he had called me the day before and told me that, so I wouldn't have at least had to drag my client down to Norwalk at 8:30 in the morning. But the judge inquired, well, did you call defense counsel, let her know? And I said, no, I had no idea. I wouldn't have had my client here. And I would have talked about alternate dates for the trial continuance with his office. The judge disbelieved the young associate, so asked for the courtroom that counsel was in trial, the department, in the case name, left the bench, went back, called that trial judge and that clerk, and he was not in trial there. That trial had been continued the week before, so he misrepresented all of that to the trial that trial court in Norwalk. And she came back out, let the young associate know that she knew he was not in fact in trial, and set a hearing for 1:30 and ordered that counsel to be down there at 1:30 that afternoon. So, in talking to the young associate out in the hallway, I advised him that he needed to work for another firm, get a new job, basically, if because he was lying to the young associate too, and the associate had to take the heat. And 1:30, the judge sanctioned the attorney. The sanctions were over the amount that were reported to the state bar. So trial subsequently did get continued. He did continue it the next week. So anyhow, that's my work.
Next, we can talk about attorneys shouldn't make statements before a jury. So this is for those of you that will try a lot of cases that might prejudice the case. Speaking objections have been ruled to be improper. Offers of proof can be improper, and that's based on the Kenworthy versus State of California case. Offers to stipulate can be improper in front of a jury. Requesting an order from the court at that point in time can be improper. Moving to amend a complaint in front of a jury is considered improper. And a claim that the opponent has suppressed evidence was considered improper in a case. So any effort to secure an advantage by means of falsity is clearly probably an ethical violation, as well as touching on the civility rules vis-a-vis the courts and attorneys.
But Maria, realistically, how many speaking objections have we dealt with? I mean,
that's the irony. I mean, judges, obviously, with this new standard, I think have to become maybe a little more forceful, because you'll have this discussion before trial. You may have done a motion in limine on some of the things that you didn't want the attorney to say or bring up, and yet they will do it. So clearly it's on the judiciary as well to become more, heavy-handed, shall we say, or enforce some of these rules. And that was going to bring me to a general discussion, which we could do at the end if Lori has something else at this point. But I do see some problem with the new requirements. I do see it being a bit vague, a bit ambiguous as to what's reportable, what's considered incivility, what is going to happen to an attorney that you report that of. I actually tried to call someone at the bar today, but apparently because of their lack of employees, you're put on hold for over 40 minutes, and I wasn't able to speak with someone. But just as a practical matter, I'm sure it went through all of our minds that, how is this supposed to take effect? Even the pledge idea, it sounds like a great idea, but when do they expect you to think about that or do that? Is when you renew your bar dues, and I noticed it might have come up, and so they want you to read it. Are you to do it at a meeting with a bar association, and how often? And then the whole reporting of the incivility conduct too. I'm really a little puzzled about how that's practically to take effect. So if anyone has any thoughts or comments, I would appreciate your input.
well, Maria and I always rail against the bar, especially after the Girardi case, making us suffer through all these things of having to snitch on each other and having to be the ones that have to like self-report or report other people, being put in the position of, and that's kind of uncivil in a way too, being put in a position by the state bar of having to make phone calls and report other attorneys. I don't know how much, unless it's super egregious, like the cases we cited and talked about. I don't know if all of us want to be put in a position of having to snitch off other lawyers all the time. Just because there was a bad actor, like the Girardi case, then they change all the client trust accounting reporting, and we're all subjected to all of that. And you're supposed to snitch off other lawyers. And I don't like being put in that position. Do you have any comment about that, Maria?
No, just the same kind of comment that it's a burden, and I think we worry too that it can be abused. Then it is contentious, so you have a contentious attorney, and then he finds a way to utilize these new requirements to report you to the bar or just cause you some discomfort. It'll probably end up fine, but meanwhile you're having to go through some hoops, perhaps. That one anonymous letter saying you did X or Y could be very troublesome, especially to a solo practitioner, small firms, small practice individuals. It could be quite burdensome.
Yeah. I mean, that's one of the subjects we talk about, that we don't like being in the position of having to report other attorneys for something we may perceive, because are we the arbiters or the judges of that behavior? But it would be helpful if the judges were a little more stronger in this area, stopping either trial or hearings when they see abusive behavior. And my experience so far is I haven't seen that. I have not seen the judge put an end to what could be very disrespectful behavior. I had a case years ago for the judges in Pasadena, who I actually had tried a fair amount of cases in front of, and plaintiff's counsel would constantly on sidebar talk over me, and then the judge would talk over me, and they were talking about things that clearly could have become appealable issues. And counsel would constantly say, I'm going to appeal this, and that's why. And so I wanted to get on the record why it was an appealable issue and our position, because I needed a record of that in case the case did in fact get appealed. I needed to get that on the record. So it became, just everybody talking over each other. I'm sure the court reporter was having a fit. I'd look at the court reporter every once in a while because she was having a tough time taking down the record when everybody's talking over each other. So I think it behooves the court to interject and stop that kind of behavior. If counsel's talking over you and you cannot get on the record, you need to say that in a forceful manner and make that clear that you need to be on the record on whatever the issue is, and that you think it's uncivil behavior that counsel's talking over you, and it's uncivil to the court reporter who's trying to take down that record.
Now that we have 8.4.2, maybe we can, cite that specifically in the record, which could be helpful. And I noticed in sort of looking at the history of how this came about, the bar indicated that their sampling indicated that women and minorities were the ones that apparently were indicating that they were having a repeated conduct that they found uncivil or difficult to deal with, which led again to the committee being created and some of the legislation that we now have. And secondly, to people that are maybe less experienced, newer attorneys, it behooves you to be as courteous as possible to the court clerk, the bailiff, if there's a bailiff in your courtroom, the jury adjutant that some courtrooms have. Everyone in that courtroom deserves and needs that respect and show of civility. And believe me, it'll pay off. People will notice that. The judges will notice that. If you have jurors in a case, they will observe those behaviors. So all of these things are really only going to help you and your client be that better advocate, get that better result, because your negative personality traits aren't turning somebody off. It comes down sometimes to small things like that.
And just Yeah, I agree with Maria, just being kind and nice to everybody. What's interesting about the civility subject, when I was reading about it, the state bar and acting and everything, is they do see a bias component to it. In other words, that it's part of bias training.
Right.
So they see it maybe that, there is a bias component to it. And I'm not sure what that is, but they talk about there being a bias. I, you I would try to work that in, but I just couldn't figure out how.
Yeah, it was just touched on, as I indicated, where they've obviously surveyed attorneys, and we had a survey, I think, with our bar due renewal this year. And there have been times, and for that committee, there might have been specific survey material. And like I said, it seemed to be that women felt more mistreated, and minorities apparently felt that way as well. And so it is a part of the
Bias.
MCLE.
Bias.
Dovetails with Diane
Yeah,
and ethics.
yeah. But how to work that in, and
Right.
tonight, we weren't sure. We did talk about that, but we weren't sure how to do that. Okay. Attorneys should not fight or intimidate either opposing counsel or party. Attempts to harass, intimidate, or annoy the opposition by physical conduct or the making of faces is improper. And they talk about several cases. People versus Bradford, which was a criminal case, where the defendant accused the prosecutor of making faces, etc. And then the prosecutor accused the defendant of flipping him off and mouthing phrases like "F you." People versus Kelly is another criminal case where the defense attorney said that, told the prosecutor if he was interrupted again, he was going to kick her under the table, kick your ankle under the table.
I've seen that done in deposition, by the way. So is that why some attorneys have the clear glass tables in their conference rooms? So you can see when you're kicking your client or vice versa, right? It does happen. You'd be surprised,
Anyone who says they haven't kicked a client in a deposition is probably lying.
Bob, I haven't kicked
Yeah,
a client in the deposition.
Oh,
Okay,
I've been
I've
tempted.
been a client.
I've never done that. I can actually say that. And so anyhow, and then finally they talk about a civil case where the plaintiff lawyer, and I'm not picking on plaintiffs' attorneys, in Love versus Wolf, said, "Can I make a statement or two without being interrupted, or do I have to floor you?" And on another occasion, opposing counsel were invited to step outside and do something about it. I actually knew an attorney that no longer practices, a great guy, that the plaintiff attorney and him got a big argument inside the courtroom, and they went out in the courtroom and threatened to have a fist fight right there. That's never a good thing or civil behavior.
Right.
So if you can avoid a fist fight with opposing counsel, that's probably a good thing. And that's on both of them. They both shouldn't be.
And we may, all of us may have had the experience too, where someone just invades your space. They're inches from you, talking loudly. Luckily, maybe they have a bailiff in the past. I was another thought that came to mind is that are people seeing more issues because a lot of the civil courts have no bailiff anymore? I used to really feel comforted by having a bailiff in the courtroom to avoid those behaviors. And if you follow the news, you've seen this spate of defendants, leaping at the judges. So I think I'm wondering, how that dovetails with this new civility thing. But we've both experienced, if you've practiced long enough, the attorney who will go out in the hallway and get within inches of your face and yell at you because they weren't happy about a ruling that the court may have made, let's say. That kind of behavior. I've had litigants threaten me. I actually haven't had an attorney actually threaten me.
But it was always kind of a comfort to have a bailiff in a courtroom. So I'm sort of saddened that that maybe isn't going to come back just for budgetary reasons. And even maybe the judiciary may have regretted uh, making those budgetary constraints some years ago. I don't know if anyone else has any comment or thought on that as well.
Okay, so we're gonna try to wind it up. Another,
You're
at least not to their
How
face.
dare you?
At least not to their face. Let's save it later. So that's hard to do, but you should do it in person, I suppose. It, but it's, human nature, I think. And I finally want to end with, two things: how to respond to misconduct. It seems like you can file a complaint with the state bar, but again, we get into issues.
Right.
How much do you want to snitch on each other? What's the level of misconduct? I think if somebody's out and out lying, I think that's misconduct and you can prove it. And maybe that's reportable to state bar. Short of that, if it's just bad behavior, that's on the attorney and their reputation, I think. The reputation is important. My word is important. So hopefully, professionalism comes into professional conduct.
Yeah, it'll hold you in good stead. I had issues where someone made a motion about some issue in a case that I'd left that law firm, but because I had a reputation with this judge, he actually, kind of put the kibosh on the motion and said, I know Miss Skinner and she wouldn't have said or done that. So you'd be surprised how your reputation, it's really a relatively small community in the legal world. It really, is important. And if you've been practicing as long as we have, you can see that it'll pay off dividends if you're always as kind as you can be to others, even in a contentious business.
Yeah,
Right.
it is. It's an adversarial situation. And that's why I don't know about the snitching on each other. And so let me check the chat box and see if we have any questions. I don't see any. If anybody,
Is that good or bad? We covered it, or
yeah. So I don't see any questions in the chat box. Does any,
there you go. You were cutting out just a bit right there.
okay, I don't see any questions in the chat box. Does anybody have any questions about any of the material that Maria and I covered? No? I hope we did a good job. Everybody, thank you tonight. Again, I'm setting up February's meeting and March's employment law. Scott Wheeler's going to do that. Any new and significant changes in employment law. So what we're going to do, I think this year, is call upon more and more of our members to actually do the MCLEs. Because for a lot of reasons, if you do an MCLE, you get 3 hours as opposed to 1 hour. That helps with obtaining hours. But I think also using real life experiences and real life examples is helpful to everybody. I always invite everybody. I think part of belonging to a bar association is networking, that if you have issues that come up, I would invite you to call one of our members, Maria or myself, regarding these issues, because maybe we can help you out. If we can't help you out, we'll try to find the answer for you or someone that can answer that question.
Right. And if you have any suggestions for topics or speakers for the year too, that probably be helpful as well.
Right.
Or give
Right.
some ideas what you want to hear about.
Right. And just as an example, last year, Greg Lucette did a presentation on closing your practice, either in the case of retirement and death, and it's posted on our website. And I just had an attorney contact me the other day. Years ago, I had an attorney find out he was terminally ill and, wanted some help and guidance. And of course, I felt horrible. It was a terrible situation, but things like that are helpful through the bar association. So, we're here to help. And I hope you found this
Absolutely.
helpful tonight. So with that, we'll say goodnight. Jason, anything you want to remind everybody to sign in so they get the credit?
Yeah, yes, make sure you fill out your record of attendance. You should have gotten the email about a minute ago. So, and then you should all receive your MCLE certificate in your emails from now on. So that's the only announcement.
Okay.
Thank you. Good night, everybody.
Good night, everybody. Thanks.